Please be seated. Hereby, I open this academic ceremony in which Stefano Balestieri will defend the academic thesis entitled The General Anti-Abuse Rule under the Anti-Tax Avoidance Directive, a critical examination of its role in combating tax abuse within the internal market and the legal implications of its transposition across EU member states. And I welcome everyone here in our beautiful aula and also everyone who is watching this academic ceremony online. Very good to have you all. Dear candidates, may I please invite you to present a summary of your study and the conclusions of your thesis.
Distinguished Prorector, esteemed members of the Corona, esteemed supervisors, dear friends and colleagues here. I will now present a brief overview of my research and some of the conclusions that I have achieved. The research question that I address in this thesis relates to the normative value of the ATAD-GAR as introduced by the ATAD Directive and the legal consequences in its implementation in the member states' legal orders. In 2016, less than 6 months after the proposal by the Commission, the Council adopted the ATA Directive, which laid down rules against tax avoidance practices within the EU. Unlike the other corporate tax directives in place, which aimed to remove tax obstacles within the EU, promoting the grouping of companies in the internal market, the ATA Directive aims to set a minimum framework of anti-avoidance rules within the EU with the objective to protect on one side the corporate tax basis of the member states and on the other to prevent a shifting of profits from the EU to low tax jurisdiction in third countries. Among the purposes that the ATAD intend to pursue, there is the intention to also prevent a fragmented implementation of the OECD BEPS action by the member states, and so to create a harmonized framework in the internal market. Article 6 of the ATA Directive lays down the general anti-abuse rule, that is the main topic of my research, which consists of 3 paragraphs, where the first one codifies in normative terms the abuse test that the Court of Justice developed in the field of direct taxation when applying the EU general principle of abuse. And in particular, the paragraph 1 codifies the 3 main features of the abuse test, which is the subjective, objective, and artificiality elements. In particular, we see that the paragraph 1 imposes an obligation upon the member states to combat, to tackle tax avoidance, differently from the other corporate tax directives, where the anti-abuse rules present in the legislative text were defined by the court as reserve of competence, giving the member states a leeway in their application based on domestic tax law. Paragraph 2 gives a content to the artificiality test that in paragraph 1 is defined as a non-genuine test, which provides as a characteristic for an arrangement to be considered as non-genuine the fact that must be put in place for non-valid commercial reason which reflect economic reality. Paragraph 3 relates to the consequence of finding of abuse. In such a situation, the member states, as we said, is under an obligation, a duty to disregard the arrangement for tax purposes and recalculate the corporate tax basis of the taxpayer according to its domestic tax law, because the ATAD-GAR and generally the ATAD applies in the field of corporate tax. The scope of application, the characteristic of Article 6, it applies to taxpayers which are subject to corporate tax in one or more member states, and Article 1 of the directive refers also to permanent establishment of entities resident in third countries. The particularity of the Article 6, also in this case differently from the other corporate tax directives, is that the taxpayer, the provision does not require the taxpayer to have a specific legal form and does not require that the entity must be tax resident in a member state. The gateway for the ATAD-GAR to apply is that the taxpayer must have a corporate tax liability, because the aim of the ATAD of the Article 6 and in general of the ATAD is to protect the corporate tax base of the member states. So if there is not a corporate tax liability, there is not necessary to protect a potential loss in the corporate tax of a member state. From the territorial, remaining in the personal scope of application, as the gateway, as we said, is a corporate tax liability, transparent and fully exempt entities are out of personal scope of application. Another interesting feature of the Article 6 is that it applies within the EU for cross-border arrangements, but also not only for that, but also in purely domestic situations or situations involving third countries. So from the perspective of the territorial scope of application, there is no limitation in its application. For the ATAD-GAR to apply, three conditions must be satisfied. First of all, this must be a tax advantage. Without a tax advantage, there is no abuse. If the taxpayer must have, of course, a corporate tax liability, and in this sense, I refer to must be liable to corporate tax. So it's not necessary that as an actual amount of tax to pay, because the an abusive arrangement can also affect the level of the losses of the corporate, and so anyway, the taxpayer would have a tax advantage in that sense. The third condition is, of course, that the three tests, the subjective, objective, and non-genuine test, must be fulfilled altogether. In the end, the function of the GAR, of the ATAD-GAR, is to fill in gaps, as we say. That means that the ATAD-GAR must catch what the ATAD-SAR, in this case, miss, where the SAR is a special anti-abuse rule that aims to tackle a specific type of arrangement. One subject of research is also about the validity of the adoption of the ATAD-GAR in respect of the Article 115 of the Treaty on the Functioning of the European Union. This is an article that provides power of harmonization to the Council by adopting directives that aim to harmonizing the national laws or regulation or practices, administrative practices, which may directly affect the functioning of the internal market. In that regard, to assess if the ATAD-GAR satisfy the purpose to improve the functioning of the internal market, I analyzed the case law of the Court of Justice in regard of the other harmonizing article present in the treaty, that is Article 114, and in that regard, the Court found two main conditions for the EU institution to validly have use of the harmonizing articles. First of all, the existence of differences between the national regulation of the member states is not per se a sufficient condition for the EU to adopt harmonizing measures. Such differences, according to the Court, must be of such a kind to effectively obstruct or restrict the fundamental freedoms in the internal market. The other condition is that the harmonizing measure must be aimed to prevent the development of distortion of competitions which affect the internal market. Therefore, according to these conditions, I argue that the Article 6 is not fully compliant with Article 115 in the sense that the ATAD it doesn't aim to remove tax obstacles in the internal market, but on the contrary, impose a duty on the member states to combat tax avoidance, and also duty to the individuals to the companies to avoid to adopt abusive arrangements. So the only element that I consider that the court could accept in case of a ruling regarding the validity of the article with Article 115 is the purpose to prevent the uncoordinated implementation in the EU of the anti-avoidance rules. And this because the Court of Justice has held that the EU enjoy a very broad discretion regarding the application of the harmonizing measures. The limit to such power is the situation where such harmonizing measure is manifestly inappropriate to pursue the objective of requested by the measure. Therefore, I consider that in case of a ruling on this issue, let's say, actual lenient approach of the court will not consider invalid the Article 6. Therefore, I consider Article 6 ATAD that introduces a common minimum standard regarding general anti-abuse rule in the EU can be qualified as a codification, normative codification in the field of corporate taxation of the abuse test of the general anti-abuse principle of the EU as applied by the Court of Justice through the abuse test as we saw before. In this regard, the interpretation of the Article 6 cannot depart from the case law of the Court of Justice, regardless the wording that is used in an article, as the content must not depart from the case law. In this regard, the court also held that when the member states transpose a provision of minimum harmonization, the national transposition measure must be assessed in light of primary law, which include also general principles. Another issue that I address is the method by which the member states have transposed the Article 6 in their legal order. And by analyzing such methods, I divided the member states in three groups, where the group A include the member states which implemented the provision by a specific legislative act which did not depart from the scope and wording of the original text of the ATAD. Then group B include the member states which transpose the provision by a specific legislative act, but broaden the scope of application either regarding the personal scope of application, including other type of taxpayers, or the type of tax, going beyond only the corporate tax. The last group include the member states which didn't transpose the directive through a specific legislative act, but notified the Commission that they already had in place an equivalent rule, either in a form of judicial doctrine or in a form of statutory norm. The Netherlands is in red because at the time of finalization of this thesis, the Netherlands notified to have already in place the false legis doctrine that was considered equally effective. But to my knowledge, from 1st of January 2025, had introduced a specific article, Article 29EI, of the Corporate Income Tax act that reproduce the same wording of the ATAD-GAR, and so, of course, the application is limited to the corporate tax, so it's part of Group A. What does it mean that this type of analysis? What brings with it? Brings with it what I argue that the Zozzi doctrine applies for the member states of Group B and C. What does it mean? It means that the Court of Justice can be asked to give preliminary rulings also in situations that are out of the scope of the original text, because the member states of Group B and the member states of Group C have explicitly or de facto apply the same solution to situation falling within the scope of the original text or with the text of the implementing measures. And so this give the taxpayers the opportunity to raise questions to the Court of Justice. So, in the end, I conclude that I consider the ATAD-GAR a normative codification of the general principle of prohibition of abuse developed by the Court of Justice. I argue that it's not fully in line with Article 115, but at the same time, the actual approach of the Court of Justice makes highly unlikely that can be considered invalid. And this is okay. And the ATAD-GAR doesn't remove tax obstacle, but impose duties on the member states to address and tackle any tax avoidance practices that affect its own corporate tax base. And in the end, according to the way how the member states have transposed the ATAD-GAR, I argue that triggers the application of the Zozzi doctrine, and so gives the Court of Justice the right, the possibility to give a preliminary ruling on request of the national courts. Thanks for your attention and being here, and I give back the floor to the prorector.
Thank you so much for your presentation. The opposition will be opened by Professor Tjurts, who is Professor of International Tax Law at our university and who is also the chair of the Assessment Committee.
Yes, so thanks a lot and congratulations to the thesis and your presentation. I would like to start maybe like, why do we need general anti-abuse rules? We need them because the taxpayer sticks to the wording of the tax law, but not to the spirit of the provisions. And in many jurisdictions, we may find it difficult to ignore the wording or interpret provisions contra legem, as you also describe in your thesis. So, that's why we introduce general anti-abuse rules, to follow the spirit despite the wording which would provide for other tax consequences. You explained the wording of the ATAD-GAR, which has a subjective, objective, and artificiality test. And the subjective test says the main purpose or one of the main purposes. So the wording is clear. One of the main purposes is the threshold to continue with those tests, to look at the object and purpose of the relevant tax rules and to test artificiality. Nevertheless, you argue that you can ignore the wording of the GAR and follow the sole purpose or the essential purpose, so a much stricter test or more favorable test to the taxpayer, and recommend to clarify this, basically assuming that that is indeed the case, that it's not one of the main purposes, it's the sole or essential purpose. And I was wondering why. You will probably say because you need to follow, you need to interpret the ATAD-GAR in line with the court's interpretation of the EU General Anti-Abuse Principle. But is it not the result which matters, rather how we get there? And is it not the follow-up test, the object and purpose of the law and the artificiality, which is much more important? One of the main purposes is only the starting point of the investigation, and if you then continue with the tests and end up with the result, it is a wholly artificial arrangement or not, and this is in accordance with the general anti-abuse principle, is it not the result which matter rather than each specific test as such? Thank you.
Highly esteemed opponent, thanks for your question. Yeah, it's indeed the wording used in the Atadgar has been subject of, in the literature of a lot of, let's say, positions regarding that. First of all, I assume that as the GAR is a provision that deprive the taxpayer of an advantage that has raised applying a specific tax provision. It's and goes against what is the principle of legal certainty in somehow, no? Because the legal certainty, the principle of legal certainty requires that the taxpayer must be in a position to predict what is, to know what is right, and predict what is the outcome of these, let's say, choices based on a tax provision. And the GAR is a rule that the tax authority used to requalify, recharacterize such behavior. So the point is that the interpretation and application of the Atadgar must be conducted, taking into account all three elements so the subjective, objective, and purpose, because, for example, can happen, there's a situation where an arrangement can have, can be assessed as non-genuine, but at the same time, the tax advantage, there is no intention by the taxpayer to raise a tax advantage. So in this case, if we consider only the, for example, the stratificially test as a main test to apply in such a case, we would consider abusive, what in reality where there is not intention to gain an advantage from the taxpayers. So regarding the wording, main purpose or one of the main purposes, the point is also that the Article 6 is a provision of minimum harmonization, and as such must be interpreted in line with the general principles, because otherwise we would have let's say, a situation of conflict between the application of the rule compared to what the case law, what the Court of Justice has developed, and the case law of the Court is also a source for legal certainty for the taxpayers. So if we depart from this interpretation aligned with the case law, we can have a situation where the taxpayer can be in a situation, in a position where there is no intention to abuse for tax purposes a certain situation, and in the end it's deprived of the advantage that raised from the tax rule.
Are you satisfied with the answer?
Yes, thank you. I may pick up if there is time for a second question.
Thank you so much. Now the opposition will be continued by Professor Selicato. Professor Selicato is Professor of Tax Law at the Sapienza Università di Roma and is also a member of the Assessment Committee. And I would like to welcome you very much to Maastricht University today. Very good to have you here with us. You have the floor.
Thank you, Mrs. Chairman. Thank you also to all colleagues that wanted me in this commission. And first of all, Stefano, congratulations for your work. It's a very detailed and deep and analyzed work. I have not an opposition, Mr. Chairman, but only a such of step forward, I think, in your reasoning that is correct. And you correctly say that the ATA directive doesn't take into consideration the topic of the risk of double taxation. Indeed, you have shown in your slides which is the purpose of the directive, that is that of counteracting tax avoidance and tax abuse. But I was thinking about double taxation because there is a sort of natural effect that if a directive imposes the state of the company which has the control of another company in a state where there is a shifting of tax base, this obliged that state to tax the income shifted in the other states entirely, as it has never shifted in the other state. So this implies that the other state could not remove the taxes applied in virtue of the principle of sovereignty of each independent state, and this could realize double taxation. So the question is, if we have an article in the directive that is 8.7, which allows member states to recognize the deduction of taxes paid abroad, but there is another article, that is Article 7.2, which states that this is not possible when or whether there is a artificial arrangement. I am asking myself, and I'm asking you, don't you see that this implied an infringement of the freedom of movement of the business inside the EU if the other state is another EU member state? Because also this is, and I finish my question, also this is clearly stated in your thesis, and that the object of the GAR is extended to domestic and non-EU cases. But I think that in relation to the double taxation issues, we have to distinguish the European case from the other two cases, domestic and non-EU, because undoubtedly in the case where two member states are implied, we have all the list of general principle of EU taxation that, in my view, could not admit the double taxation. So, which is your view on that?
Highly esteemed opponent, thanks for your question. And indeed, the topic on the potential double taxation arising from the ATAD rules has been recently addressed by the GCOCOT in opinion released a few months ago on an infringement case. First, regarding such a possibility, I recall the preambles of the directive where this issue is addressed, in the sense that the directive in the preambles require, in principle, the member states to, in case of double taxation due to the application of the rules, to provide relief. But as we know, the preambles have no legal binding effect, and in the corp of the directive, there is not a procedure that allows members or obliges member states to find somehow a solution to a case of double taxation arising. Indeed, the point regarding double taxation, there is no a procedure in the directive, we said, double taxation has been recognized by the court, by the Commission as an obstacle to the correct functional internal market, but other side, there is no harmonizing measure or anyway a EU legislative measure that resolve or gives guidance how the member states should approach and resolve. And this is an old issue regarding, for example, which state should give the relief on that issue. Going to the point, more specifically, you referred to the article of ATAD regarding CFC rule. Indeed, the application of the CFC rule within the EU has been addressed by the Court of Justice, and clearly any article of the directive must, not only because is a minimum harmonizing measure, but in general is a measure of secondary law, must comply and must cannot go against, cannot restrict a fundamental freedom. So, the double taxation, as I remember, Agiko Kot said in opinion, is not a right for the taxpayers. So, must be addressed according to the implemented rules, or if in case of EU, in absence of this harmonizing measure, cannot be addressed, cannot be, let's say, addressed by, from the EU perspective, but must be addressed by the single member states. It's, of course, when addressing the kind of situation in deriving from the application of the ATAD, from my point of view, and I write in the thesis, should also come into place Article 4.3 of the treaty. That is the obligation, since the cooperation between the member states in giving effect to the EU provisions and to refrain from jeopardizing such a measure when implemented. So the double taxation is an issue. In the thesis, I argued that should be addressed with the specific procedure or amending the ATA directive or amending the directive on the dispute resolution that originally the Commission included as a scope of application any source of double taxation within the EU, but then was amended and now applies only regarding of double taxation arising by double tax treaty in place among the member states.
The opposition will now be continued by Professor van den Broek. Professor van den Broek is Professor of Tax Law at Radboud University, Nijmegen, and he is also a member of the Assessment Committee. And I would also like to welcome you very much to Maastricht University today. Wonderful to have you. Please.
Thank you very much for the invitation to be here. Dear candidates, I would like to congratulate you with your PhD thesis on such an important and topical issue as Article 6. And I must say it is a real accomplishment to write a PhD thesis along founding and managing your own law firm in Rome. Congratulations with that. I would like to ask you a question about conclusion 3 of your scientific research regarding Article 3 of the ATAD. This provision allows all member states to adopt anti-abuse measures that are stricter than those of the directive itself. And on page 391, you stated Article 3 ATAD does not give any actual leeway to the member states to adopt stricter GARS rules within the European Union. And in footnote 1735, you refer to De Broe and Beckers, for example, who wrote in 2017, in light of the criteria of the abuse concept set out by the ACJ in its case law, and the boundaries resulting from this concept for national anti-abuse measures in order to be compatible with the fundamental freedoms, it is highly unlikely that member states may enact more stringent GARs than that of the ATAD, at least in cross-border situations. So also the Broe and Beggars, they relate a stricter GAR to the fundamental freedoms. But I would say, as long as a stricter GAR is applied in the same way in cross-border situations as in domestic situations, the fundamental freedoms are not at stake at all. These freedoms, they would be hampered if the stricter GAR is applied only in cross-border situations and not in domestic situations. And only then the stricter GAR needs a solid justification, and only then it has to be in line with the proportionality principle. So let us imagine that one of the member states introduces in this national legislation a stricter GAR that applies both in domestic and in cross-border situations. Would that be allowed under EU law? Or could taxpayers argue in front of a court that such stricter GARs violates EU law? I look forward to your answer.
Highly esteemed opponent, thanks for your question. And indeed, Article 3 has been also a subject that now in literature has been addressed. Because, of course, especially in relation of the cases regarding the leeway left by directive to member states to apply more stringent national provision compared to the directive of minimum standard as the ATAD. Well, the point is that I think that it's true that the court in the field of taxation applies the comparability test in order to see if the national provision discriminate or better apply a less favorable taxation or situation to a cross-border situation compared to the domestic one. It's a topic that anyway was addressed by in the Aeropark case that any national measure that implement the let's say a minimum article or directive must be assessed against the primary law and not against the directive itself. In a case where member states introduce a GAR that is stringent compared to the abuse test that we saw in paragraph 1 and applies irrespective of both situations, of course in this case there will not be a comparability test or discrimination test. Anyway, as the GAR doesn't how can I say, can provide a restriction, can restrict the capacity of national to to claim a fundamental, to move into the EU context. Of course, it's an open question, but I see that in order to prevent that the member states could reduce the rights that the EU gives to the national member states, there could be a restrictive effect on that the taxpayer could somehow raise to see if the court can follow such a position. So clearly the discrimination approach would not apply in such a case. It's just a political choice of the member state, but nonetheless I see some room for in somehow raise a question of a restriction if, of course, the level of the national GAR, so the level of departure from the minimum standard in sense of more stringent way is enough to give a room for raising a position of, let's say, an issue of restriction for the taxpayer to apply, to enjoy the fundamental freedoms. So yeah, it's an open question. There are different positions in the literature about the actual application of Article 3. Also in regard of this point, I think that, and from also a practical, a political position of member states, I see only the possibility to implement new rules, stringent compared to the ATAD-GAR, applicable only in domestic or in situation with third countries. And for example, the PPT is one example in this, of course, not within the EU, but in respect to third countries, a possibility.
But in principle, you agree that Article 3 allows member states also to change the application of Article 6 and make, to some extent, more stricter rules.
The point is that I consider the Article 6 expression and reflect the EU general principle. So I don't think that, I think that Article 3, if we see from the discrimination perspective, could in principle allow the member states to apply a stringent rule, but such stringent rule, anyway, I see that it could be, should be compliance with the general principle as primary law of the EU. So honestly, I don't think that a stringent rules anyway would pass the let's say, assessment in light of the EU general principle of prohibition of abuse.
Thank you so much. The opposition will now be continued by Professor Breuer, who is Assistant Professor of European and Procedural Tax Law at our university, and who is also a member of the Assessment Committee.
Dear candidate, I have read your thesis with great interest and congratulate you with it. I also noticed that you refer to case law doctrine of the Court of Justice on several occasions. For example, in chapter 9.3, you discuss the application of the Joji doctrine. You say that this doctrine applies also to member states of Group C, as you call it, which are member states that have not transposed the ATAD-GAR into national law, referring instead to their pre-existing domestic GARs. You say also that regarding those member states that fall in Group C, there is a manifest interest in a uniform application of the ATAD-GAR, and you then assert that these member states have de facto, as you call it, decided to apply the same solution to all personal and objective scope of their pre-existing national GAR. So, if I understand you correctly, the national GAR would have to be applied in accordance with the interpretation of the ATAD-GAR, even in, say, the case of inheritance taxes on natural persons. So, what would you say to a member state of Group C that has a long-standing tradition and a well-established case law on abuse in inheritance tax matters, which does not fully align with the ATAD-GAR as interpreted by the EU? Would they have to throw their long-standing case law out of the window? Maybe you could elaborate a bit more on the Joji doctrine in case of member states of Group C.
Highly esteemed opponent, thanks for your question. Yeah, indeed, this situation is what happened in Netherlands, because if I read correctly the documentation, the Minister of Finance, when presented the law, budget law 2025, and where that introduced the your GAR as a norm, refer the fact that this implementation does not affect the case law of the based on false legis as it stays. The point is that the Zozzi doctrine is a doctrine that the Court of Justice developed to protect its task to give a uniform, let's say, safeguard the uniform interpretation, application of the EU law through the member states. So there is a clear separation between the task of the Court of Justice and the task of the national courts and the national legislation. So if we assume that the states like Italy, for example, consider their national GAR already in line with the equally effective as the ATAD GAR, and so broaden the scope de facto of the ATAD GAR to include the taxpayers and all the taxes that are applied based on the domestic GAR, it's a choice of the member state. So in this situation, and I assume also the same Netherlands may be thought to introduce a domestic GAR by a specific legislative act to prevent some sort of, let's say, enlargement of the application of the ATAD GAR. So the point is that if the member states didn't implement a specific legislative act, de facto include within the scope of application of its national rule, national GAR that is considered as a transposition of ATAD GAR, the taxpayers and the taxes that are on which the already national GAR applies. And it's the same situation of the member states of Group B, with the difference that the boundary of the scope of application of the national GAR in the member state C is the same of the previous. Regarding the reference to the inheritance tax, clearly it's a point that is part of the member states' legislative choice. So if the member state has a GAR that applies also to an inheritance tax, so there is not a different provision, the moment where it considers its own rule as equally effective to the ATAD GAR, it's implicitly importing the concept and also the rights deriving from the EU law connected with the ATAD GAR. And so it's a point on which that I just confine within the member states' legislative decision and choices.
Thank you very much.
Thank you so much. The opposition will now be continued by Professor Korving, who is Assistant Professor of European and Corporate Tax Law, and who is also a member of the Assessment Committee. Please.
Thank you. Dear candidate, congratulations on your incredibly lengthy elaboration on the ATAD GAR. I've read your thesis with much interest, and I especially liked that you didn't limit your research to the ATAD GAR, but place your research in the broader context of EU anti-abuse rules from other EU directives and the EU anti-abuse principle. My question follows the questions raised by Professor Van den Broek and Professor Breuer, where they ask for situations where member states chose for stricter implementation. Member states can also opt for more lenient implementation. Whether that's correct or not is something different. In January 2024, Dr. Scherleitner and myself published a 33-page article titled Article 6 ATAD, Living a Life on Its Own. And in that publication, we discuss 5 different dimensions of the ATAD GAR, amongst which its relation with EU state aid rules. ATAD aims to improve the internal market, also via providing a floor to regulatory competition that takes place via tolerating that certain taxpayers decrease their tax burden via exploiting certain tax planning channels. State aid rules also want to prevent harmful competition. To what extent do you think the misapplication or non-application of the implementation of the ATAD-GAR can lead to incompatible state aid? I look forward to your answer.
Highly esteemed opponent, thanks for your question. And yeah, I refer in my thesis, for example, to the NG case where this issue was raised by the Commission, but was not in the end held by the Court of Justice. Because first of all, the Article 6 is a minimum standard. That means that oblige the member states to at least implement that abuse test, and therefore to have national guard that don't satisfy at least those conditions would be against the Article 6, so would be open for infringement procedure by the Commission. Regarding the relation with the state aid, clearly the implementation of the ATAD-GAR serves also the purpose to prevent harmful tax competition between member states in regard of applying more lenient, let's say, or tax administration approach or tax rules that could create a spillover negative effect, for example, to the other member states' tax, let's say, treasuries, because now the fact that the member states are under an obligation to have at least that kind of protection for the corporate tax base means that to depart from not only such rule, but I would say also to depart from how the Court of Justice will interpret such rules would constitute a sort of selective, let's say, advantage provided for the taxpayers that could advantage, for example, based on rulings where the tax administration now before the ATAD-GAR could have a sort of more lenient approach, of course, always subject to, in case of an assessment from the state aid rules. But what before could happen as a sort of harmful tax competition in sense of too lenient rulings, now the harmonization, even if in a minimum standard of the ATAD-GAR, brings with it that the case law of the court on such issue becomes a benchmark for all over the EU member states in order to comply with such obligations. So any departure from such, let's say, positions or such standards would indeed constitute, from my perspective, a breach of the state aid rules and could be basis for a procedure from the Commission. And the NG case, in fact, the court, even if it didn't accept such a reason, nonetheless accepted the idea that in case where the tax administration depart from the ordinary, let's say, practice or case law, national case law, in applying the anti-abuse rules in its member states, could be considered as a source of unlawful state aid. So I absolutely consider the two, let's say, the connection between the two topics, but the fact that the ATAD-GAR has been now transposed into the member states' legal order brings also, in terms of also legal certainty for, in this case, let's say, also the taxpayer, and somehow that the member states and the tax authorities have now the also obligation to follow the benchmark that will be set by the Court of Justice.
Yes, but you now take this. You then take the starting point that the member state concerned actually implemented the ATAD-GAR correctly. But what if they didn't implement it correctly? Because then it can result in a situation that if you would have applied the ATAD-GAR correctly, something would have been considered abusive, while now, because of the misinterpretation, misapplication of the ATAD-GAR, some sort of benefit will exist for the taxpayer. And is that benefit then state aid? And in parallel of that, what would the European Commission need to do? Would they need to fight that with the state aid provisions, or should they start an infringement procedure, or should they do that in parallel, or what's the solution for the European Commission?
Yes, but it depends if this implementation is generally applied to the taxpayers, or we are referring to a misinterpretation, for example, just within a specific area, specific, let's say, group or specific taxpayers. I think that, to my knowledge, until now, the Commission didn't open an infringement regarding the application of the ATAD-GAR. Nonetheless, to answer to your question, in such a case, it depends if this misinterpretation or misapplication is generally applied. So in this case, I would consider the infringement procedure as, of course, the procedure followed by the Commission, or the application for specific case, specific situation, specific type of taxpayers. In that case, I think that if there is just a point of misinterpretation, the state aid, of course, rules. If the point is connected with this implementation, I would move on the infringement procedure.
Thank you.
Thank you so much. Now it gives me great pleasure to allow Professor Van den Broek to raise a second question.
Thank you very much. I would like to raise a second question on a topic that we already discussed about, and that's about the risk of double taxation in case anti-abuse measures apply. And you write on page 397, conclusion number 6, that you consider this risk of double taxation particularly concerning, significant oversight, and really problematic. And all 4 of your recommendations in your PhD thesis, they address this risk of double taxation under the GAR. I will not specify all the recommendations now for the purpose of time. So you suggest to introduce, for example, a mechanism to alleviate double taxation. But my question is, from the point of view of society, is this really, this double taxation, is this really that problematic as you state? The GAR only applies if the tax administration can prove, also in front of a court, that a taxpayer has set up an artificial arrangement for the main purpose of obtaining a tax advantage that defeats the object and purpose of the tax law, and it is not genuine. Yeah, and I would say, in the first place, double taxation does not infringe the fundamental freedom of taxpayers, not even in bona fide cases. So one could say, what is the problem in case of tax avoidance? And the second point is, wouldn't it make much more sense to set up a mechanism to avoid double taxation for bona fide cases, instead of worrying about cases of tax avoidance? Thank you.
Highly esteemed opponent, thanks for your question. I agree on the principle, but in practice, the double taxation that I see can emerge from the application of Article 6 is can be also based by a simple different interpretation by 2 member states. So one can consider that arrangement as abusive, but the other one not. So, and also regarding, for example, on what is a valid commercial justification. One member states can accept a justification that another member states can consider not sufficient. So, indeed, the double taxation, also in the case of abuse, I think that in order to provide to avoid to apply a sort of penalty for a taxpayer that is in a situation where one member state consider abusive its position while the other not. So I think that it would be, in this case, we cannot refer to the nature of the, in this case, double taxation as a sort of deterrent penalty to prevent the abusive arrangements. So I think that...
You may briefly conclude your reply.
Thank you. So in this case, as this situation can happen, I think that to provide a solution for double taxation is in line with the principle of legal certainty and also in line with the fact that the different interpretation are practically can happen, and so we should find a solution for the taxpayer that can be in this situation.
Stefano Balestieri, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company present here in the aula will await the results of our deliberations at our return here in this room. Stefano Balestieri. The degree committee here present has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taken into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor van den Hurk is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisor to take the floor.
Stefano, first the official part. Do you promise to work in accordance with the principles of scientific integrity at all times? To be careful and honest, transparent, independent and responsible?
I do promise.
By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Stefano Balestieri, the degree of doctor, in which all the rights attached by custom and law. As evidence of this, I now present you with the degree certificate signed by the rector, the secretary and the other members of the committee, and affixed with the official seal of the university. And I'm just going to first put some things aside. Here it is. And my congratulations. Please be seated.
Dr. Balestieri, dear Stefano, it's a great pleasure to see you bring this long process to an end. When we started about 8 years ago, I received an email as many others. Every month you receive an email from an external person who would like to write a PhD, and we know them. You often recognize them, half of them are written by AI nowadays, but okay, that was 2017, AI was not really invented yet. But still, we got monthly emails about whether we would be willing to write an email. So you were one of those many, because we did not know each other before we had our first talk. And I wondered, and I was looking back in my archive, what made me select you to start off with? First of all, your email was very detailed, very to the point, very matching in every way. So the AI of that time would have had a lot of trouble writing such an email. But more importantly, when I got in touch with you to ask or email back whether we could have a Skype meeting, that's something also historic, the first thing you said, no, let me come to Maastricht. So I have this potential person from Italy that I've never seen before, and the first thing he tells me, even for a first meeting, yes, I come to Maastricht in person. And you kept doing that over all those years. Despite that, the fact that Rome is, of course, not close by, you, I think, are already a record holder of frequent flyer miles from Rome to Maastricht and back. That was something that also showed your commitment on this process. A commitment that allowed you to finish this process after 6 to 7 years, nearly 8 years if we take it up to the date. But it was a process where I look back on, where when it comes to external PhD thesis, a process that I would like to see with more theses, where people really come, where you have a close heart-to-heart, really in-depth discussions. And we were just discussing also with my colleague Hans van den Hurk, we had some discussions. We don't all agree on what's in your thesis, we have our differences there, we discuss that, but you show yourself grow in that process. And that is something I think you should keep doing. Even now with your PhD, I think that's even an invitation to keep doing this and try also to convince others to get to that kind of discussions. I hope that with this certificate, there is something of a even part-time academic future for you in place. And I wish you all good luck with things that are coming to you. Congratulations again.
Dear Dr. Balestieri, also on behalf of Maastricht University and its Faculty of Law, many congratulations on the degree that you have just acquired. Your academic journey went from Rome through Vienna to Maastricht, as also one of your supervisors already referred to. Here in Maastricht, you received something that all universities have in common, namely the highest degree we have available in academia, and that's a doctor's degree. Many congratulations on that. Also congratulations to your family and friends, partly here present and partly also participating online. And I wish you all the best also in your future academic career. There will be a reception where it will be possible for everyone present here to congratulate the young doctor. We will also go to that reception with one stop in between at the stairs, where we're going to take the traditional photo of the young doctor together with your paranymphs, who did a very, I think, good job today, and with your supervisors and with the entire committee, and of course our BIDO. I already saw that we have at least 4 skilled photographers here in the audience who are going to help us with the taking of that photo. Congratulations again, and with this I also officially close this academic ceremony.